Good morning, good morning, good morning. How y'all doing today? Oh, it figured just as I'm getting ready to go live, I get a phone call spam. I check to see who it's from, and it's from my insurance company. So they need me to give them a call back. So I'll give them a call back as soon as I can after the stream is over. But anyway, I've got my cup of tea here and I'm ready to go. A piece of breaking news that just happened about 18, 20 minutes ago, even though it shouldn't surprise anybody because I've talked about this before. Our buddy Adam Schiff and his residences, shall we say. Um, he's got that tiny 650 square foot studio apartment in California that he claims to be his primary residence for him, his wife, and his children. And then he owns that multi-million-dollar home in Maryland that everybody actually lives in. I assume that when he goes back to California for fundraising and electioneering and such, that he may or may not stay in his tiny little apartment. And the family stays back in Maryland, living in the big house. But that, for election and holding public office, he claims that that tiny little apartment is his primary residence. And there's been some questions about his about the mortgage paperwork. And I brought that up. An article on that. Well, just a few minutes ago, this article popped up. It says 15 minutes. That was 15 minutes, and I pulled the article up, so it's probably been closer to a half hour. Trump accuses scam artist Adam Schiff of possible mortgage fraud and stunning attack against political rival. Well, pencil neck Schiff for brains there. Yeah. Now, I like this here. This is Mediaite. Former President Donald Trump launched a personal and detailed attack against longtime political adversary Adam Schiff on Tuesday, accusing the lawmaker of years-long pattern of possible mortgage fraud in a post on a social media platform, Truth Social. Now, here's the actual post. I've always suspected Shifty Adam Schiff was a scam artist. And now I've learned that Fannie Mae Financial Crimes Division have concluded that Adam Schiff has engaged in a sustained pattern of possible mortgage fraud. Now, I did a quick Google search, and there is nothing out there from Fannie Mae saying this. Nothing that I could find. Like I said, I did a quick one. I only spent about 5 or 6 minutes looking it up because I had a couple other things I needed to get done before I started the stream. Adam Schiff has said his primary residence was in Maryland to get a cheaper mortgage and rip off America while he must live in California because he's a congressman from California. Now, remember, this here's what they've done this primary residence thing against Trump, and Lita James is now caught up in this, with her multiple houses that she owns, and whether she claimed primary residence in multiple states to get lower interest rates and even to get the mortgage. And the problem with her is, though, that the law says that she must be the resident of the state that she works for as Attorney General. So she's claiming a house in another state as her primary residence. She can no longer be the Attorney General in that first state. Let's see here. I've always known Adam Schiff was a crook. The fraud began with the refinance of his Maryland property on February 6, 2009, and continued through multiple transactions until the Maryland property was correctly designated as a second home in 2020. Mortgage fraud is very serious, and crooked Adam Schiff, now a senator, needs to be brought to justice. Remember, they took a misdemeanor, the Democrats took a misdemeanor crime and an accounting error and blew it up through rewriting of law and quote unquote, a novel reading of other laws in order to get, and then using a once in a lifetime jury instructions. All 12 jurors didn't have to consider all 34 charges. Each juror was given a block of charges, and if found guilty by the four jurors, they divide the jurors up into groups of four. And they gave a block of charges to each juror, to that group. And if that group found Trump guilty on that block of charges, then it would be considered that all the jurors found him guilty on that block of charges. And they did that in order to get 34 felony convictions against Trump. And you'll hear Democrats to this day, liberals to this day, we've got a felon in the White House. He was found guilty of 34 felonies. So that's, and once again, I'm going to say this once again. This has been over a year now, I believe, that these convictions have come. Yeah, it's been over a year. And the appeals court still hasn't handed down a ruling. And I don't understand why. I don't understand why the appeals court hasn't handed down a ruling on this yet, but that's neither here nor, that's another questionable thing going on in Donald Trump's life. So should they go after legally, criminally against Adam Schiff? In the world of political payback, yes. In the world of, and a homeowner, a home purchaser who's just buying a second home because he has to go back and forth between two different states, to do their job. If it was a non-politician, I would say, know, make them pay the back taxes, make them pay the back more, the increase in interest rate and everything else, make everybody whole. Because remember, when you've been named something as your primary interest, as your primary home, you pay less property tax on it, and your mortgage interest rate is lower, a lot lower in some cases, like by half. So make them pay all the money that they owe for the however length of time, the back property taxes, and then of course, penalties, you know, double it up. If he owes, let's just say it's $3,000 a year difference on the property tax, and he's got to pay $6,000 for each year. If the mortgage interest rate is a $300 a month, that comes out to 3,000 plus another 600. So 3,600 times, so multiply that, be $7,200. $7,200 for each year goes to the mortgage company. But Adam Schiff is a politician. And he's a politician from California, supposedly representing Californians. But if his primary home, his family lives in Maryland year round. And he never lives in that studio apartment. I call it a studio apartment because, it's half the size of my house. And while as a single man, I could live in a smaller house. I could live in a house half the size of what I've got if I were single. So if he only lives in that studio apartment when he's back electioneering, and the family does not live there, the kids do not go to school there, et cetera, then he should be removed from office immediately. And California, whatever laws they have regarding this kind of actions, should be strictly applied. And if it's criminal charges, so be it. Hold Adam Schiff accountable for his actions. Hey, morning, Ramen. You're not a snitch, but start searching the basement, cardboard box, Grandma's Lisbon vacation slides, 1983. Best place to start. Oh. So, yeah, I want to see, and it'd just be pure enjoyment for me because I am still angry. I am still how can I put this? Back during Ukraine phone call, the wonderful phone call between Trump and the president of Ukraine. The perfect phone call. And that weaselly eyed colonel made accusations. And then Adam Schiff got up there in the Senate, leading the impeachment hearings against Trump. Lied into the congressional records about that phone call. And not one single, I do not remember, I'll have to watch the videos again, but I do not remember one single Republican standing up and calling him out on the way he totally misrepresented and lied about what was said in that phone call. But it got read into the congressional record as if it actually happened that way. And I still have, to use a military terminology about this, I still have a hard on about that. And I would love to see that wrapped around the end of a baseball bat, the fat end, with barbed wire, broken glass, and sand, and then rammed up Adam Schiff's anal cavity without the benefit of lube. But that's just me, you know. I do take impeachment hearings rather serious. I do take testimony that is read into the congressional record rather serious. And that was just absolutely beyond the pale, and he was not called out on it sufficiently. So, would I be surprised to find out Schiff has, broken the laws here? Would not surprise me one bit. But anyway, I'm done talking about Adam Schiff for now. So let's jump over to the Supreme. Well, wait a minute. No, I need to go to, where's this guy at? Here we go. I need to go to the traitor. I need to get this off my chest here this morning. Retired Army officer pleads guilty to leaking national defense info on foreign dating site. A retired Army lieutenant colonel that's 2 steps down from the general ranks. You got lieutenant colonel, colonel, then general. Remember, you go butter bar lieutenant, second lieutenant, first lieutenant, captain, major, lieutenant colonel, colonel, then you hit your 4 general ranks. Be my little general, brigadier, major, lieutenant, then just plain general. So this guy could be, and if in the Air Force, he could be a squadron commander. He could have several hundred people working for him. He would be responsible for discipline, including recommending courts martials, administrative discharges. He could ruin people's lives at this rank. This lieutenant colonel who worked for the Air Force as a civilian employee has pled guilty to conspiring to provide classified information through an online dating app to someone claiming to be a person in Ukraine. On Thursday, 64-year-old David Slater entered his guilty plea. He's 1 year younger than I am. A Justice Department news release said Slater, after retiring from the Army, was an Air Force employee assigned to the U.S. Strategic Command at Offutt Air Force Base, Nebraska, where he held a top secret security clearance. Between February and April of 2022, Slater is charged with conspiring to share classified national defense information that he learned from Strategic Command briefings about the ongoing Russia-Ukraine war on foreign dating website with someone claiming to be in Ukraine, who'd refer to Slater as her secret informant love and her secret agent. Slater's arrest in 2024 came around the same time Airman First Class Jack Texeria, then a guardsman with the 102nd Intelligence Wing at Otis, entered a guilty plea in federal court disclosing sensitive information online. Slater was originally charged with 1 count conspiring to transmit and 2 counts of transmitting classified information related to national defense. As part of a plea deal, 2 counts of transmitting were dropped. So they really got him down to the least of the crimes. They took away the ones that could have got him, honestly, as far as I'm concerned. Again, this is my personal opinion. Put before a damn firing squad. This is where he needs to be. They need to start stepping down here against these people, especially a lieutenant colonel, a retired lieutenant colonel that's bringing home $8,000 or $9,000 a month in retiree pay. What does a lieutenant colonel, retired lieutenant colonel, make in retirement pay? Retirement pay for lieutenant colonel. Let's just say he had 20 years. He retired at 20 years. 5,000, okay, at a minimum, his retirement, he was bringing home $5,500 a month in retirement pay. At a minimum. That's if he retired at exactly 20 years. So I wasn't, when I said between 5 and 6, I wasn't off by, I was right there. I was right there with what his minimum retirement pay is that he's bringing home right now. Some snippets of the correspondence between Slater and the individual on the dating website were detailed in the indictment. The alleged Ukrainian wrote a message to Slater in March 2022. Dear, what is shown on the screens in the special room, it is very interesting. Dave, I hope tomorrow NATO will prepare a very unpleasant surprise for Putin. Will you tell me? Slater responded with the information regarding military targets and Russian military capabilities relating to Russia's invasion of Ukraine. It is not clear what Slater's current employment status is, and the Air Force's Strategic Command spokesman did not respond. if the minute he was charged, the minute he was arrested, the minute he was charged, he should have been fired. Absolutely 100% fired. Terminated. Terminated with prejudice. What the hell? It's unclear. Slater could face up to 10 years in prison, 3 years of supervised release, and a fine of $250,000. He's scheduled to be sentenced on October 8th. He's 64. That put him 74. Screw it. Make it 94. Put him in prison without parole for 30 years. And then if he manages to live to 94, then put him on 6 years of supervised release and a fine of $1 million. Put that boy in the poorhouse. Take take away all of his retired military benefits. Every one of his military benefits should be out the window. He should never see another military benefit for the rest of his life. He should any money donated to his commissary should be immediately confiscated and put against his $1 million fine. This was an officer in the United States Army. With a top secret clearance, willing to give up information to somebody who said they were a sweet little woman in the Ukraine. I don't know if they ever actually identified who it was that he was talking to. Hey, Digi, good morning. Raman, I'm getting curious about what you got there in that one post about going to grandma's basement. I'm kind of curious what you got going on there. I have real serious heartburn about military and the actions thereof, people in the military. I talked yesterday about the changes in the different uniform regulations. I'm talking online on TikTok to several active duty Army guys. I'm in active discussion on this. I have, and I, I've said it before. I'll say it again right now. I have a serious problem with anybody who is active duty posting social media while in uniform, especially when bitching about their commanders, bitching about their first sergeants, bitching about their uniform requirements or what, and making accusations that it's all racist. I have a serious problem when active duty military are doing that on social media. It is my personal opinion that anybody and everybody that is doing these social media stunts while in uniform should non-judicial punishment. An Article 15 action, not a letter of counseling, not a letter of reprimand, not even a letter of admonishment. but an actual Article 15. What about just posting jail? Did you? Okay, when I was active duty, again, back in my day. Now, when I first started posting uh, and this is back on the old days of AOL and posting to bulletin boards, I went to legal office and talked to them and asked them about it. And what they advised me was that one, not to talk about anything job related to what I do. I worked because I worked on the flight line at the time. The less I said about the military itself, the better. Now, if I wanted to discuss politics, that was fine as long as I was not saying I was active duty military while saying it. As a member of the United States Air Force, this is what I say. Because now it could be considered you are speaking for the Air Force. And then when the systems got better and you could actually do camera stuff, I went back to the legal office and talked to them about that then. And they said again, don't do anything while wearing any military outfits, not even the green t-shirt or brown t-shirt. And make certain I don't have anything in the background that was military related. Nothing with my units or anything else. So that in no way, shape, and or form could I be identified, could it be misconstrued that I was talking as a representative of the United States Air Force? I mean, I fully encourage, we lose a lot of our rights when we join the military. Like it or not, when you join the military, you lose a lot of your rights that a normal citizen has. And with today still being, I mean, it's been what 30 years now of an all voluntary military. We haven't had an active draft since the 1970s. So what? That's called the 80s, 90s. It's been 50 years of a voluntary military, all voluntary forces. No one can claim that they were forced to join the military. Now, there were those who were given the option, join the military or go to prison or go to jail. But even that doesn't happen as much as it used to. Oh, wow. Huh. Okay, I haven't kept up on that case at all, Ramen. I'm surprised you're not asking for a electrified butt plug, tasered butt plug be stuck up in with you holding the magic key. I'll have to look into that case some, Ramen. But anyway, so yeah, I, yeah. I also saw a video yesterday, but it was it was last night. I saw this video. This army woman in the army. She's about 5'6", and if she didn't tip the scales at 300 pounds, I'll eat the difference in weight. I'll give her $1 for every pound difference. And she's sitting there eating one of them big ass Dubai candy bars. You know, the ones with the green filling and coated with chocolate, pistachio filling. That's what it is. And she's sitting there eating that thing, wolfing on it, and then saying how nasty it tastes while she's wolfing on it. What the hell is she doing in the military? But anyway, so yeah, I want to see this lieutenant colonel. I want to see him sent to prison for a very, very, very long time. All right, the next thing I want to talk about. Let's see what's okay. I can close that one. All right, Trump actually got a big win out of the Supreme Court, and this is something that I wholeheartedly approve of. The Supreme Court is allowing President Donald Trump to put his plan to dismantle the education department back on track and to go through with the laying off of nearly 1,400 employees. With the three liberal justices in dissent, the court on Monday paused an order from U.S. District Judge Myong Yoon in Boston, who issued a preliminary injunction reversing the layoffs, calling into question the broader plan. The layoffs will likely cripple the department. Well, no fake. The department needs to be crippled. It has gone well beyond its initial uh, design. The Federal Appeals Court refused to put the order on hold while the administration appealed. The High Court action enables the administration to resume working on winding down the department, one of Trump's biggest campaign promises. In a post on Monday, the social media platform Trump said the High Court has handed a major victory to the parents and students across the country. He said the decision will allow his administration to begin the very important process of returning many of the department's functions back to the states. And that's where the education department should have been in the beginning. Back to the states. Our federal government has gotten too damn big with too much control over our lives. If you read through the Constitution and it lays out exactly what the federal government is responsible for, and remember, you know, anything not prohibited to or listed here belongs to the states and to the people. And that education department, it grew, when it first started, and I believe it started under Nixon. When it first started, it was a good idea. But like anything, the people got, they got up there and they decided they needed more and more and more, and let's do this and let's do that, and well, let's let the federal government do this and let's let the federal government do that, and well, we need to be able to do this, and we need to be, and pretty soon you got a damn monstrosity that's got their fingers and tentacles into every aspect of our lives. And then you get a very liberal or very conservative group of people running that department for any length of time. I've flat out said before, I do not want a a religious government. I do not want a government ran by theologians. I don't want ministers. I don't want priests. I don't want preachers running the federal government. I don't want them running the state government or the local government. And the reason for that is real simple. The problem would be is like what's happening in some states where a Muslim comes in, a Muslim community comes in, and next thing you know, you're hearing the Muslim call to prayer across the publicly owned speaker systems 5 times a day, shutting down the roads 5 times a day for prayer. I'm not Muslim. I do not want Sharia law enacted in this country anywhere. That is why I do not want a religious government, because if they've got it, if you say, yes, we want a religious government, then pick the religion. Pick the religion that you want to run the government, because I'll almost guarantee that at least half the people won't like the religion you pick. Oh, you're right about that, Rom, about too much money going into teacher hotel conferences and other trips. You're absolutely right about that. And it's like the Head Start program. I really, yes, I've said this before. My wife works for the Head Start program. She has, as long as we've been married, she's worked for Head Start. And the idea of Head Start's a good idea. Okay. To assist lower income parents so the job and start to be granted a head start on the education. The idea is wonderful. However, in practice, it doesn't work the way the idea does. My wife spends hours every night, 6 nights a week. She spends hours working. She works primarily with babies and toddlers. So she, with her toddler she's going over colors and the letters of the alphabet and what, shapes and all this other good stuff. And she spends a lot of time coming up with lesson plans and ways of teaching these kids. And the parents come in, they drop off their kids, they're wearing pajamas, they come pick up the kids, and they're still wearing the same pajamas. The parents aren't going out to looking for a job. They're not going out to school. They're going back home down in their Section 8 housing and going back to bed. And that's the long and short of it. Well, Raman, you're right. There are private Muslim schools, and just as there are private Christian schools and private Catholic schools and private non-denominational schools. And I've got no problem with that because, public tax dollars aren't going to these schools, to these private schools. And I don't agree with public tax dollars going to public schools unless the public school system is failing. And then the money should follow the child. But if the public school system is a B school system, and the kids that are graduating that school system can actually read on grade level, write on grade level, then the money don't follow the kid. If the parents want the kids to go to the private school, that's on the parents. Yeah. And she'll sit down and start working on stuff for school. And I want to do something. And she'll tell me, no, she's busy. She's got to get this stuff done for school. It's like she comes home and it's like, babe, I want to go out tonight. And no, we can't go out because I've got all this work to do. And if we go out, then I gotta stay up past midnight to finish the work. So, well, my wife, she has potty trained kids. But anyway, the education department, though, the court did not explain its decision in favor of Trump as to the customary emergency appeals, but in dissent, Sonia Sotomayor complained that her colleagues were enabling illegally questionable action on the part of the administration. It's part of the administration. Just as Sotomayor had no problem with the Obama administration not enforcing immigration laws. She had no problem with that. Pick and choose which laws. Linda McMahon. I think it's so funny the consternation that there is out there about Linda McMahon being the education secretary because of her ties to the WWE. Today, the Supreme Court has confirmed the obvious. The President of the United States has had the executive branch has ultimate authority to make decisions about staffing levels, administration, organization, and day-to-day operations at federal agencies. If the Democrats in Congress are so pissed off about this going on, why did they put it under the executive branch? Because they're too damn lazy to do the job. That's why. They create these agencies, give them the power of making rules and regulations that have the uh, enforcement of law without actually being law, regulation of any one of these agencies. You can be fined millions of dollars for breaking a rule regulation of these agencies, but there's never been a law about it. And depending upon the agency, you don't even get to use a regular court. You have to go through one of their courts, staffed by their picks for judges and such. So, we lose all the way around. The plan said the lawsuit will continue, adding no court has yet ruled the administration wants to do is legal. Let's see, if you're told that you can go ahead and start laying people off with no intent of hiring them back, yeah, that's pretty much being told it's legal. I love the fact that the Democrats are so enthused about making the federal government part of our everyday lives. Yet they want to sit there and whose streets? Our streets. Power to the people. Trump is returning power to the people and taking away from the federal government, which is as it should be. The federal government should not be sitting there demanding what is taught in our schools and how it's taught. That should be up to the parents and the local school boards, not up to the federal government. Because I don't agree with what the federal government's pushed through, just as you wouldn't agree with what I would. If I had the right to determine everything that was taught in the school system, that half the country be uh, out with torches and pitchforks. Because that first thing they'd be doing is starting to learn how to write in cursive in first grade. They'd have those, yeah, they'd be learning how to print, but they'd have those little guidebooks that you put the pen in and follow the indentations for learning how to write in cursive. Remember those? To build the muscle memory. You know, I got a set of those for my grandchildren with all the numbers so that they, by the time they got into kindergarten, they could write all their numbers. 0 to 1, 0 to 9. They could write every number and write it legibly because I got them that. They could write the entire alphabet. My grandson, by the time he got into kindergarten, could write the entire alphabet A to Z and all of his numbers. If you told him any number up to 100, and I think it was 110, but once you get to 110, you can write the rest of them. That's no big deal. But he could write any number you gave him and write it legibly. So yeah, I thought I stopped sharing. Well, wait a minute. No, now here's something that I disagree with Trump on. Will Democratic states sue Trump administration over $6 billion in frozen education funds? Democratic officials from 24 states and the District of Columbia sued the Trump administration on Monday, seeking to restore billions of dollars in frozen education funding. The states lost on funding for after school and summer programs, teacher training, English language learners, and support for children and migrant farm workers, among other initiatives. Had the responsibility to do that in so many years that for some of this stuff, the parents need to be weaned back into taking responsibility. You can't just dump it on them because the kids will suffer. Okay, the children will suffer. They need to have the chance to go to these learning events throughout the summer so that they can learn what at least retain what they were taught throughout the previous school year. Now, there's probably that money. I agree. It's, uh, migrant workers. That's not my job. That is not my job to teach the children of migrant workers. That's uh, my job is to fund the education of the children of United States citizens. That's my job. Especially when these classes for the migrant workers are held almost explicitly in Spanish. They're not teaching them English. Now, we do have the ESL classes, English as a second language. But those classes should be specifically for children of legal immigrants, not illegals, legal immigrants. That's pretty much where I stand on that. That $6 billion that's been frozen, that's been allocated to mostly the western states. California gets a large chunk of that, and so does Texas, but California gets a large chunk of that. In his complaint, the U.S. District Court of Rhode Island lawyers for the state said the decision to freeze the funds had caused chaos. The suit named defendants as Linda McMahon, President Trump, Russell Voigt. Sorry about that. The states had already planned for the upcoming academic year, which is set to start in weeks in many areas, in reliance on the billions of dollars that are now frozen. The budgets for many local education agencies have already been approved, and staffing plans have been developed so the LEAs can perform the responsibilities for the impacted programs. California Attorney General Rob Bonita said in a press release that the freezing funds alone was not no rhyme or reason. His office is freezing the block in $939 million in funding for California alone. Well, guess what, California? You spend more than that giving Medicare and Medicaid and other taxpayer benefits to illegals. Don't come whining to me that you got a shortfall in education money when you're spending a crap ton of money on illegal. When you're spending over $1 billion a year on illegals, don't come crying to me about any money that you're not getting from the federal government for educating your students. Don't come whining to me about it. You guys in California keep bragging how the United States depends on California because y'all provide so much money in taxes and such to the federal government. But then you turn around and waste so much money of that money back on illegals. So what now? And now part of this problem, though, see, Congress has funded this as part of this year's budget. Yes, again, the president can uh, uh, and has spending authority, but when Congress specifically says such and such money has to be spent on such and such, and it's been signed into law, unfortunately. Now, on any new bills coming before President Trump, he can veto them if they include money that he doesn't like. Because our president does not, and for good or bad, our president does not have the line item veto. And line item veto, of course, is a lot of governors have it where the bill comes up before them, they can say, "Yeah, I don't like that," and they can strike through it and veto that line of the bill. And then that line has to go back before their legislature to either override the governor's veto or let it stand. And a lot of times things will get put into bills that in states that have the line item veto, just get them passed knowing that the governor is going to line item veto that item. They put it in there to get it passed, to get the other party's votes for it, or enough votes for from the other party to get the bill to pass. Raman, I'm right there with you. I can't wait. I mean, they're already throwing up fits because that's something that's on the drawing board of making sodas, gums, candies, cakes, where you can't buy those on EBT. And I'm looking forward to that. So, all right. Now, last but not least, this here, well, being that it's already 10 o'clock, this is probably going to be a two-parter here because I've got things I've got to do yet today. So, and I think an hour, I don't know, I'm not going to make it through this, but President Trump had his first judicial nominee of this term passed the congressional vote yesterday. And I went and found her hearings. Now, during the last administration, I didn't play a lot of the questions being posed by the president's party, by the Democrats, because for the most part, they're softball questions. A few hard balls thrown in there here and there, but mostly softball ones. So in fairness, I'm going to play a lot of Democrats and very few Republicans. Now, I am going to play Marsha Blackburn and John Kennedy, because I absolutely love their questioning. They're very rarely softball questions. What school did you go to? Or the whole thing is nothing but one speech. So let's see how much this we can get through here today. Let me go ahead and share this video. And hopefully I'm using a trick here that I don't have many commercials. Again, we shall see if this works. I just don't want to pay $13 a month to be commercial free, to be honest.
Senator Durbin.
Breaking news. The number one cause of heart attacks and strokes isn't hypertension. It isn't cholesterol. Too much red.
Thanks, Mr. Chairman.
Well, I see that didn't work. So we'll have to put up with a few seconds of commercial every now and again, it looks like.
This is an historic meeting for the approval of federal judges. We're doing things differently today than they've ever been done since I served in the United States Senate. What's happened? Well, a decision was made last week by Attorney General Bondi that the Justice Department would no longer cooperate with the American Bar Association rating process for judicial nominees.
No wonder. The ABA absolutely hates conservative judges.
What's going on here? Why is this being changed so abruptly? Well, you look back.
It's not abruptly. It's been threatened for years. It has been threatened for years by almost every Republican president since Reagan.
And you can understand it if you look at the history of it. During the first term of Donald Trump, the names were submitted to the American Bar Association of each of his judicial nominees. 9 of those nominees were found unqualified to serve on the federal bench.
Unqualified per the ABA and their opinion. Remember, this is the ABA's opinion, the American Bar Association's opinion. They don't have any objective standards. It's all opinionated.
By the American Bar Association. Yet President Trump in his first term pursued it anyway. 8 of them ended up being approved for the bench. What is that all about? The American Bar Association has a process of going to the peers and colleagues of the nominees and asking, what was your experience in the courtroom as a judge, as co-counsel, as opposing counsel? What did you think this individual was doing in their professional capacity? Were they prepared for the case? Did they comport themselves honorably? Just basic questions. And the nominees then are subject to rating by the American Bar Association. Qualified.
Based upon opinion. Nothing objective, just opinions.
Well qualified, unqualified. Under Trump's first term, as I mentioned, 9 or 10 were found unqualified. 8 of them were approved for lifetime appointments to the federal bench. All right. So, Durbin, what about your nominees under President Biden? 235 were approved by this committee. Were any of them found unqualified by the American Bar Association? Not one.
Including some that couldn't define what a woman was. Could not define what a woman was, and yet the ABA said they were qualified to be president.
So the difference is the Attorney General has decided to protect against the vulnerability that some nominees, maybe even some today, might have been found unqualified. I think that's a mistake. I think that kind of professional evaluation, which has been going on under presidents of both political parties for decades, should continue. But the Trump administration, second term, has decided the ABA is no longer welcome to review judicial nominees. That's a mistake. And then there's the Trump administration's rejection of the Federalist Society. The Federalist Society. I asked this question for 20 years, literally 20 years. What's going on here? Why is this the secret handshake of all the Republican nominees, that they belong to the Federalist Society created by Leonard Leo and others? What does it mean? A lot of the nominees would say, oh, it's just a free lunch. Go and listen to a lecture. It doesn't mean a thing. But it turns out to be a recurring pattern that if you're going to be considered as a serious nominee on the Republican side, you've got to be part of the Federalist Society. But guess what happened just recently? Last week, President Trump wrote on Truth Social, I quote, "I am so disappointed in the Federalist Society because of the bad advice they gave me on numerous judicial nominees," quote unquote, from President Trump. He also called one of the organization's longtime leaders, Leonard Leo, quote, "a real sleazebag," close quote, who, quote, "probably hates America."
They probably had some sort of a disagreement. We all know how Trump is. If you disagree with him on something, you're dead to him. He is going to call you names. But then he is going to be just as quickly to accept you back once you start agreeing with him again on another subject. So I'm never going to say Trump isn't mercurial, because he absolutely is.
From President Trump's own mouth. Yet during his first presidential campaign, then candidate Trump, quote, said, "We're going to have great judges, conservative, all picked by the Federalist Society."
Hey, this is Senator John Ossoff in Georgia. $5 Can you chip in
Nope.
President Trump's mindless inconsistencies are a classic example of situation ethics. But when they toss out the American Bar Association and they toss out the Federalist Society, they don't want anyone looking over the shoulders of the nominees to find out what they believe, what they've said, what they've done. I don't get it. I don't think that's in the best interest of picking the right people for the judiciary of either political party. And then there's this issue that the chairman raised, and he and I are friends, so this is not a personal thing. We have been wrestling with this, at least between us in conversation for weeks, about how to resolve it. Here's what it boils down to. Trump's first term, 94 U.S. attorney appointees, Democrats in majority in the Senate. Boy, that must have been a battle royal. It was not. They were all approved by voice vote in the committee.
What he's complaining about now has absolutely nothing to do with judicial nominees. So I'm going to skip this. I'm going to skip his little whine here.
Isn't personal. We've got to find a way out of this that is fair and bipartisan, and that we're going to stick with for both political parties. You just can't change the rules overnight, and that's what we're faced with. So, Mr. Chairman, this is more than just the ordinary.
I'll tell you, Dickie Durbin, you changed rules so many times during the last administration that don't sit there and pretend you didn't, because you did. There was constant complaining about you changing the rules or not following the rules.
Meeting of the nominees to be considered by this committee. This is the first time no ABA involvement. The Federalist Society is now a suspect sleazebag group when it used to be the required approval before anyone's taken seriously. And we still have to resolve the mess left behind by Vice President Vance.
I don't expect you to know that.
He'd been a whiny little baby about Vance. So
Yes, but I had at least one conversation with it.
You want me to hear you?
Yeah, but I want to tell everybody,
I want to go
or
ahead.
at least my colleagues here, that I had at least one conversation with one of the senators other than Vance that was holding up nominations, because I thought this set a bad precedent. Maybe you and I can work it out, can
I
we?
hope so.
Okay. I do have a short rebuttal to what you said about the ABA. The ABA can still send letters to the committee, just like any other organization. But Attorney General Bondi's decision to no longer provide them special access to nominees is hardly surprising. For decades, Republicans have criticized the progressive bias of the ABA. These complaints aren't new and are why the Bush administration stopped conferring with the ABA to select nominees. Examples of bias by the ABA rating abound. Just last Congress, the ABA told us that the Biden appointee, Charnel Kendron, was quote unquote qualified to be a federal judge. At the hearing, she didn't even know what the Article 2 of the Constitution was. The same ABA famously told us that Republican appointee Judge Frank Easterbrook, a highly respected law professor who had argued 20 cases before the Supreme Court, was in some members' estimation not qualified. The ABA has chosen to act as a partisan progressive organization. They advocate for transgender causes, racist DEI policies, and the outlandish assertion that the Equal Rights Amendment is now part of the Constitution. The ABA has recently sued the Trump administration for cutting U.S. aid funding, and its current president has publicly attacked the administration. The ABA's political bias is obvious and has been for years. It's no surprise that the current administration doesn't trust the ABA to be a neutral arbiter of the nominees' appointments. Now we'll go to Senator Blackburn to introduce.
all right, I'm going to skip by Marcia and this guy here, because all they're doing is singing praises. Now, as much as I like Hawley, I'm going to skip him here. And we're going to go to the first Democrat.
This committee and confirmed in due course on the floor of the Senate. Thank you, Mr. Chairman.
Thank you, Senator Hawley. Now, Senator Smith.
Thank you, Mr. Chairman. It is a great day for Missouri, and it is an honor, special honor to have the first four picks come from our state. I share that sentiment with Senator Hawley, and also I know it's a big day for them. It is also I feel like I can share a little of that pride with all four having worked with me in the Missouri Attorney General's office at different times and different tenure. These nominees also have something else in common. If you look at their legal experience, it's marked by exemplary public service to the people of Missouri, protecting their liberties, protecting their safety, and upholding the rule of law. I'm so proud of their careers that they've led, that has led them to this day, and that President Trump has made such spectacular picks for these important positions. They're among the finest judges.
All right. You're skipping all the way down here to Durbin.
So let's get down to
Go and skip down here to Durbin. He's leading the first questions. Get past her introducing her family.
With that power
and all
comes
that.
great response.
Get past her skipping all of her family. Okay.
Responsibility to ensure that rulings are proper in scope and legality.
Thank you for answering my question. Now it's up to Senator Durbin, but before he takes over, Senator Hawley, you will take over for me now, please. Go ahead, Senator Durbin.
Thank you, Mr. Chairman. Welcome. Thank you very much for coming before us today and bringing your great family. Terrific. Glad that they're here. So let's get down to basics. Under Article 3, is your loyalty to the law and Constitution or to the president who nominated you?
Under both Article 3 and Article 6, the constitutional oath, the oath is to faithfully follow the laws that apply in a given case.
And the Constitution?
Absolutely.
Is the executive branch required to follow the orders of a federal court?
So, of course, this is an issue before the Supreme Court right now. And
Okay, now here they're following the Ginsburg rule now. Up until Judge Ginsburg, okay, just a little history lesson here. Up until Ruth Bader, when they asked him a question, they had to answer it. Then Ruth always started saying, well, that question may come up before me when I'm sitting on the bench, so I'm not going to answer it. And is now known as the Ginsburg rule. And every judicial nominee since then has played this on both sides of the aisle. For the most part, I don't like it. I want to see these nominees answer the questions. But I also want to see these senators asking questions that aren't gotcha questions that they're going to use later to say, gotcha, you need to recuse yourself from, because all this is to keep them from having to recuse themselves from ruling on a case in the future. Because, well, I can't rule on that because I already said what I believe about this situation. So I'm obviously biased one way or another. Therefore, I can't say, well, if they're biased in the Democrats' favor, then they can go ahead and sit. But if they're not biased in the way the Democrats want it to go, then they can't sit. That's the way it goes. So, when the Democrats, well, both sides, but when the gotcha questions are being played, the nominee really has no choice but to refuse to answer the question.
What I heard the Solicitor General say is how I understand the law as well, which is if there's a judgment issued by a court as to the parties, that absolutely binds the parties, and the way to go about your business if you disagree with an order is to seek maybe a stay or emergency relief or appellate review.
And after you've exhausted all of those opportunities, is the executive branch of our government required to follow the orders of the federal court?
Yes, if the Supreme Court issues an order at the end of the appellate review process, that order is to be followed as to the parties in the case.
Ms. Hermendorfer, I'm a little bit interested in the decision that you and the state of Tennessee made to file an amicus brief in the Supreme Court in the case of Trump versus Casa. That case involved challenges to President Trump's unconstitutional executive order that purports to end birthright citizenship. President,
I love the way he's, his unconstitutional. It hasn't been ruled unconstitutional yet by the Supreme Court. Okay? You got liberal judges saying it's unconstitutional, and you're saying it's unconstitutional, but The Supreme Court hasn't ruled it unconstitutional yet. I just wish that these lame duck Republicans would make it so in law.
Trump's executive order has been blocked by a judge appointed by President Ronald Reagan, who said, and I quote, "I've been on the bench for over 4 decades. I can't remember another case where the question presented was as clear as this one. This is a blatantly unconstitutional order," referring to the order to end birthright citizenship. The state of Tennessee was not a party to that case. You filed this amicus brief voluntarily, and you reached a conclusion which the court ruled the most blatantly unconstitutional order in decades. Why?
So, of course, we were amicus in the case, and the decision was made by the Attorney General, reflecting.
Amicus, that's just saying, hey, court, I've got some information you may need. I'm filing this letter with as a friend of the court to ensure that not everything is, to make certain that you get all the information needed to make a good decision here. Amicus briefings, amicus letters have been a part of the judicial system forever. So this is nothing new. It's usually, in cases like this, is something that's ordered by the governor or the attorney general of the state. And the lawyers that work for the attorney general or work for the governor, of course, do the research and file the letters per the instructions of that person. That may not go, the letter, the individual, like in this case, if she helped write this letter, she may or may not agree with it. But her job is to write the letter in the best way she can, the best possible way, to express the desires of the person who ordered it. So just because you helped write the letter doesn't mean you agree with everything in the letter. That's just the way it goes. When it's being ordered by a state, by the attorney general, when it's being ordered by the governor or whoever. Now, when it's like a amicus filed by the ABA, by the ACLU, yada, 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 then that's a little bit of a different thing. All right, because those aren't government agencies. Those are private organizations. And if you're a lawyer working for that private organization, then obviously you're there in agreement with that private organization.
The values of Tennesseans, that we were not satisfied that all of the information regarding the contemporaneous meaning of the 14th Amendment was being presented to the various courts, given that the litigation was proceeding so quickly and at such a pace through the TRO and PI process. So our role as amicus, as is any amicus's role, which was to bring additional information that could be helpful to the court's attention. And what we did there was draw the court's attention to contemporaneous 1800s era sources regarding the meaning of the 14th Amendment.
And I've done my own research on the meanings, the 18th century discussions and debates and such. And the whole thing was basically, to boil down short and sweet, was to ensure that that slaves and the children of slaves would be American citizens. That was the long and short of it. Of the reason, but that was the long and short of the purpose of the 14th Amendment. It wasn't to ensure that there could be anchor babies. It wasn't to ensure that somebody could illegally enter your country and give birth to a child, and that child would automatically be a citizen of the country. That was not it. In fact, that's the reason why they've got the statement in there about being subject to the laws, the jurisdiction thereof. Because it's pretty well assumed that if you were in the country legally, you weren't a citizen of our country, therefore not subject to all the laws of our country.
We'll note, Ranking Member Durbin, that even in courts that disagreed with the president's executive order, Tennessee's amicus brief was called out in particular as especially well written and mentioned by the judges in the hearing. So I'm hopeful that we provided helpful information as the court considered its decision, which is all you can ask, is to ensure the court has all the information before it as it deliberates.
Did you agree with President Trump on this issue?
So the brief did not take an ultimate position with regard to the notion that this is an open and shut case is hard to square with the contemporaneous evidence and executive branch practice in the latter 1800s interpreting the meaning of the citizenship clause. And so I stand by completely those arguments and the historical sources that we advanced to the court.
You heard my opening remarks, perhaps, when I related my experience with the so-called Federalist Society. I asked judicial nominee after nominee, why do you belong to this group? Well, it became pretty clear because this was the secret handshake, the calling card, if you wanted to be considered favorably to be a Republican nominee for a federal judgeship. Well, they seem to have fallen on disfavor with President Trump. Leonard Leo has been characterized by the president as a sleazebag, and he went on to say some other negative things about the Federalist Society. So now there's a new operation called the Tenio Network. Are you familiar with the Tenio Network?
Yes, Ranking Member Durbin.
Do you realize it was created by that same old sleazebag, Leonard Leo?
I don't think I was aware of that.
What is it?
The Teneo Network, and I am a member as disclosed on my SJQ. I'm a new member, so I haven't had too much involvement, I will say. My understanding is that it's similar to the Federalist Society in that it's kind of a debating network and a networking group where individuals from across industries can get together and discuss the issues of the day and get insights into what challenges might be facing various industries.
What?
Okay. The Teneo Network, this is their website, TENEONETWORK.com. Okay. TENEO, TeneoNetwork.com, shaping American culture. Teneo is a national network where the most influential leaders, most promising ideas, and right resources come together to launch projects that reaffirm and renew the promise of the American experiment. We exist to recruit, connect, and deploy talented conservatives who lead opinion and shape the industries that shape society. What we believe in a limited constitutional government. We support individual liberty and free enterprise. We place trust in a robust civic society and a strong national defense. We acknowledge the transcendent order, whether founded in tradition, philosophy, or theology. So, and that's just the stuff off of their front page, off their landing page. So, watching this video, watching this hearings is the first time I've heard of this organization. So that's why I'm giving you all the same information, to give you a chance. Hey, morning, Paul, to give you all a chance to look them up, since Durbin is bringing them up into the congressional hearings here with this young lady. Okay. So if you want to go do some more research on them, there you go. There's their landing page. In fact, if you want, let me go ahead and I will post a link in chat. And y'all can go and read up on it yourself. So there you go.
Listen, you must lead a pretty busy life. your professional responsibilities, your family responsibilities. Why would you want to join this network so you can, well, describe for me, why would you want to join this network?
So it was commended to me by colleagues, and I'm always interested as a Tennessean in connecting with other Tennesseans to discuss the issues of the day. I have not had any meaningful involvement, given that I believe I was asked to join or invited to join a week or so before I was informed that I was receiving the nomination. And so I haven't attended since then any sort of events or been involved.
Thank you.
Did you know you can create an endless water supply using this strange homemade device? Thousands of people are extracting.
I'm going to yield my time now to Senator Blackburn. Just before I do, I just want to just clarify one thing, make sure I understood your answer, Mr. Mendorfer, to my friend Senator Durbin's question. He's asking about the CASA case. He talked about your brief filing the CASA case. The state of Tennessee was the party they're filing. Is that correct?
That's right. And there's no filing that I would ever make or have made that would not reflect the interest of Tennessee.
You're representing your clients. This is the state of Tennessee. You work for the state of Tennessee.
That's correct. I'm a state public servant who has a client and adheres to the direction of my appointed boss, the Attorney General.
And I think your amicus brief also spent a good deal of time arguing that courts do not have Article III power to bind non-parties. In other words, it's about universal injunctions or nationwide injunctions. Wasn't that a core piece of your amicus brief?
That was an important part of the brief.
Yeah, I thought so. Senator Blackburn.
All right, I like Marcia. Yeah, this is going to be a two-parter. I'll have to finish this up tomorrow, but yeah, we'll go ahead and listen to Marcia.
Thank you, Mr. Chairman. And I have 3 letters I want to submit for the record before I begin my questions. One is from Tennessee Governor Bill Lee, and then a letter from 24 state attorneys general, and also a letter from Tennessee Attorney General Jonathan Skrmetti.
Without objection.
Thank you. And to Chairman Durbin, I'll be happy.
You know, Paul, I can't argue with you that too much on that. Most people who work for the government depending on the level that they're working at, they're there for the paycheck only because it's an easy paycheck, and honestly was a DEI hire. You go into most government agencies now and the worker is either a minority or a woman. And it's been that way for a long time. So we'll just leave it at that.
To talk with him about the Teneo Network. My son and his wife and so many outstanding young individuals really benefit from that. It's been beneficial in their life. So I'll be happy to enlighten you at a future time. I want to also mention, and for all of our nominees, my Democratic colleagues ask nearly every nominee this Congress whether the executive branch must follow court orders. And then they attack the nominees if they don't give a categorical yes or a no, because the question is nuanced and it's academic. Now, yesterday we had a hearing on overreach of district court judges and the universal injunctions. Now, my colleague, Senator Kennedy, posed essentially.
I deny everything.
You can't deny this one, buddy. And so he posed essentially the same question.
I love the interactions between these two. And because they're so much alike, they really are so much alike. And the interactions are amazing between the two of them.
To the panel, asking whether they would advise a client to defy a court order. Professor Shaw was the witness for the Democrats. And here is how she answered. And I'm going to quote her. I would not rule out ever the possibility that a sufficiently egregious order, there should be some consideration if there's some way. I think it's a qualified answer, yes. In an extremely narrow band of cases, I think it would be considered yes, end quote. So the Democrats' own witness at yesterday's hearing on the issue of judicial overreach disagrees with them. I suggest when nominees are asked this question that is intended to be a gotcha question, that they just refer back to Professor Shaw's answer. I think it's unfair to attempt to conjure up disputes with a hypothetical, and these nominees are clearly committed to the law and to the rule of law. Ms. Hermendorfer, I am so pleased that you are before us. I want you to just lay out for this body why you are qualified to serve on the Sixth Circuit.
All right. Don't really need that. So we're going to jump over here. I wanted Marcia for that first part because I thought that's kind of pertinent that the Democrats' own witness in a previous hearing, just the previous day, told him that there's times where you need because the judge's ruling is obviously wrong.
And governs the legal issue that might be before the court. Of course, there are situations in which you use other tools of interpretation, statutory structure, history, precedent, and you use all those tools to get to the answer that binds the parties. And in no instance is your own view about what the policy should be govern or enter into the inquiry.
Thank you. Yield back.
Senator Whitehouse.
Oh God, I hate these ads. I guess I'm gonna have to start spending money on.
Thank you very much.
Getting ad free.
Welcome.
Thank you.
We are here in the Senate Judiciary Committee in interesting times, given the food fight that has erupted in the far right.
Now remember here, I'm playing this video sped up. And this guy is talking this slow, being sped up. I'm playing at 1.5 speed. Because of idiots like him who have to talk like William Shatner, giving that each word is so important that you must linger on every word that I say. Whitehouse is one of those people. At least Shatner, that was the way he acted. This guy actually is the way Shatner acted.
Between what I would call the Leonard Leo big polluter faction of the court capture effort and the Trump MAGA election denial faction of the far right. And
election denial, you mean like Hillary denied that Trump won, and Obama denied that Trump won, and Biden denied that Trump won. And ABC, NBC, CBS all claimed that Trump didn't win. That kind of election denial there, Senator Whitehouse?
it's going to be interesting to watch as different candidates come forward, whether they look more like Leonard Leo, big polluter faction sorts, or whether they look more like MAGA election denial sorts. But clearly, when you've got the president blowing up Leonard Leo as somebody who hates America, something is going on. What we do know is that probably $600 million was spent in the dark money court capture scheme that has been operating now for well over a decade, well over 2 decades, actually, in this country. And that still funds front groups.
Are you talking about George Soros there, White House? Are you talking about George Soros and the way he's bought DAs across the country? Is that who you're talking about?
Come before the Supreme Court on a regular basis in little orchestrated flotillas to give the justices the message as to what it is that the big donors behind that whole enterprise want. And it may
Yeah, Paul, it's amazing how they seem to forget about George Soros and all the money that he has spent over the past few decades helping the Democrats and getting them in positions of power. And honestly, when he got them all those attorney generals and district attorneys elected, he went to right to where the most effective use of his money went. Yeah, it's very rich coming from a Democrat. You're right, 100%.
be that what President Trump is beginning to notice is that the justices that he put on the Supreme Court are actually more responsive to the Leo polluter operation than they are to Trump and his MAGA allies. If you look at the record, the fossil fuel industry essentially wins every time something important to them gets before the Supreme Court. And Trump is not winning every time. And it may have come to his notice that there's a bit of a difference between who's winning all the time and who isn't.
And what does this have to do with this young lady standing in front, sitting before you there in her confirmation hearing there, Senator Whitehouse? What does any of this have to do with her?
And there's every reason to believe that during Trump 1, Leonard Leo and Don McGahn, who was his White House legal counsel, were actually operating for the benefit of the Koch brothers and the big polluters, that side of the operation.
Yeah, he did have to bring in the Koch brothers. He actually went there, even though one of them is dead. I believe one of them died.
And that's where the loyalty and the policy fell. There doesn't seem to be any doubt any longer that this, in fact, was a political operation. Just recently, the Wall Street Journal, which has long been the mouthpiece of the Leo polluter side of this current squabble, said
the Wall Street Journal has been a liberal paper for at least the past decade. One or two conservative columnists, but mostly liberal, especially in their reporting. So don't go there trying to make us think that the Wall Street Journal's a mouthpiece for conservatism, because it hasn't been. Not for at least the last decade.
Published an interview declaiming that those judges have achieved goals for the conservative movement that have been on the agenda since the 1970s. They're trying to make Trump happy with the decisions that he made and to reassure him that this is a really big Trump achievement, whereas Trump and some of his allies are starting to recognize maybe this wasn't such a Trump achievement after all. Maybe he's the one who got played in this game. Maybe all those front groups that are appearing before the Supreme Court in those little flotillas and are getting those wins are actually reporting to somebody completely else than Trump and Trump world. So this is indeed very interesting times. You are affiliated with the Teneo group, which is a Leonard Leo group. Interestingly, in the recent hearing that my colleague just referred to about the newly discovered shock that there are national injunctions going on here, the two Republican witnesses, one sat in a chair paid for by Leonard Leo and his Marble Trust operation that he runs, $1 billion slush fund for him from a billionaire, pretty sweet deal. And the other one wouldn't answer where his chair money came from. It got laundered through Donors Trust, the so-called ATM of the far right. And he wouldn't even answer whether he knew or not where the money for his chair.
Swiss engineer created a portable cooling system that's so efficient, it's making old ACs obsolete.
Was coming from. So my default proposition is that if he won't say, it probably is also Leonard Leo and the Marble Trust operation. So even in our hearings right here, we have this very potent internal food fight between the Leo polluter faction and the MAGA election denial faction. And I just wanted to take my time and point this out because I think it's highly revelatory about what has been done to the judicial branch of government by the far right. Thank you, Chairman.
Senator Schmidt.
Thank you. I want to first say a brief word on the judicial nomination success that just happened within the last week that we led right here.
Was wrong the day it was rendered. What is your view?
That power, again, comes great responsibility and humility to understand the proper role of a judge is to interpret the law and not to make the law or bend the law to whatever policy preferences the judge might have individually. And I think the justices and judge for whom I've clerked.
Paul, if you haven't noticed, I'm sort of skipping over the Republicans because a lot of, yeah, some of them, they're asking questions, but I'm trying to get through all the Democrats first. I'm trying to get through all the Democrats because they're going to be the most entertaining of the bunch.
Are models of that.
Thank you. Thank you, sir.
Senator Klobuchar.
Thank you very much, Mr. Chair. Ms. Hermendorfer, Donald Trump has said, I have an Article 2, this is an exact quote, where I have the right to do whatever I want as president. You filed a brief supporting his.
Oh, you mean like Obama when he said, I've got a phone and a pen and I can make anything happen I want to make happen? Come on, Amy. You were sitting in that chair there when Obama was president. You were sitting in that chair when Obama said, I've got a phone and a pen. So, if you didn't bash Obama for saying it, don't bash Trump. You hypocrite.
Ability to fire Inspector General. And in another brief, you supported his attempt to undermine Congress's authority to create independent agencies to protect consumers, writing, Humphrey's branch-busting reasoning was wrong the day it was rendered. What is your view of Congress's constitutional authority to enact laws and create checks on executive power?
So I was, of course, an advocate representing a client in all of those briefs. My current understanding of the Supreme Court's precedent with regard to the president's removal power is that when it comes to principal officers, so that would include heads of independent agencies, the president, if that officer is exercising, in the language of Collins versus Yellen, significant executive authority, that officer must be removed by the president, no matter the size or role of the agency. And in those cases you mentioned, Senator Klobuchar, the Supreme Court recently handed down an order staying the District Court, DC Circuit's decision, and indicating that, with respect at least to the NLRB and the MSPB, that the president likely had the constitutional authority to remove those principal officers.
And Inspector Generals, you believe the same principle applies?
So there are lines of cases discussing inferior officers. There is a dispute in the Inspector General's case about how to characterize Inspectors General. If they are indeed characterized as principal officers, then under the reasoning of the Supreme Court, there would be reason potentially to think that the Supreme Court's rule in Celia Law and Yellen might govern. There are separate lines of authority for certain inferior officers. I stand by the positions in the brief and wouldn't want to otherwise prejudge the merits of any controversy that could come before me as a judge.
Okay, let's go back to your work as Tennessee attorney in the Tennessee Attorney General's office, where you defended the state's near total ban on abortion, which does not provide any exceptions for rape or incest. The law also contained a narrow medical necessity exception that chilled doctors from providing patients with the care they need. Isn't it true that as a...
Okay, now this case here, she's talking about, I'm just going to give my opinion right now, and then y'all can draw your own thereafter. This is medical malpractice. This had nothing to do with the law itself. This is medical malpractice. It's that plain and simple. When the life of the mother is at risk, the life of the mother, not the mental health of the mother, not the other. When this pregnancy is going to kill this woman, that's totally different. That's a case where, one or the other is going to die. But this was the case this is my opinion, this was the case of medical malpractice.
a three-judge panel in Tennessee noted, the record was, quote, replete with examples of abortion care being denied in health and life-threatening situations, despite the state conceding that the medical necessity exception would have entitled them to care under Tennessee's medical necessity exception.
So the decision of the three-judge panel at the preliminary phase was that the law should be interpreted to require and allow certain abortions provided in serious medical situations. Those included the ones laid out in the order, things like premature, previable, rupture of the membranes, insufficient cervix. And so
Hey, this is Senator John Ossoff in Georgia. Not sure if you saw, but a Republican congressman who
what the state had argued was the statute that Tennessee adopted used the same language that was used and approved by the Supreme Court in the Casey, Planned Parenthood versus Casey decision. And so it was always the state's position that the language allowed abortion care in those serious scenarios. And that is what the court held. And that's what the court held as a temporary injunction matter.
Okay, so I actually met one of the plaintiffs, Rebecca Milner. She had suffered preterm premature rupture of membranes. Her baby was unlikely to survive, and continuing the pregnancy put Rebecca at risk of potentially life-threatening infection. Yet because of the law, her Tennessee doctor denied her the abortion care she needed. As a result, she traveled to Virginia. She developed an infection the doctor said resulted from the delay in care and required emergency treatment for sepsis. Given you argued the court should uphold that law, even if it didn't work to protect her health, what would you say to litigants who question?
It didn't protect. No, it was the doctor who committed medical malpractice. Plain and simple. The exception was in the law. And the doctor chose not to follow the law. It had nothing to do with the law itself. Amy actually admits that it was in the law, but she's still going to blame the law for it.
Rupture of the membranes, insufficient cervix. And so what the state had argued was the statute that Tennessee adopted used the same language that was used and approved by the Supreme Court in the Casey, Planned Parenthood versus Casey decision. And so it was always the state's position that the language allowed abortion care in those serious scenarios. And that is what the court held. And that's what the court held as a temporary injunction matter.
Okay, so I actually met one of the plaintiffs, Rebecca Milner. She had suffered preterm premature rupture of membranes. Her baby was unlikely to survive, and continuing the pregnancy put Rebecca at risk of potentially life-threatening infection. Yet because of the law, her Tennessee doctor denied her the abortion care she needed. As a result, she traveled to Virginia. She developed an infection the doctor said resulted from the delay in care and required emergency treatment for sepsis. Given you argued the court should uphold that law, even if it didn't work to protect her health, what would you say to litigants who question that you can be even-handed in applying the law, including to women trying to vindicate their rights?
So what I would say is you can read the brief and read the positions that Tennessee took in that case and that I represented on behalf of my clients. And that was there were many serious medical scenarios in which abortion under the text of the law would and should be permitted. And I would say that we were carrying out the will of Tennesseans to have that type of life or health exception, but at the same time, to vindicate a constitutional state amendment that makes clear that there is no otherwise non-medical right to an abortion under state law.
One last question. Stephen Miller has said publicly that the White House is actively looking at suspending the writ of habeas corpus, and quote, a lot of it depends on whether the courts do the right thing or not. Conservative law professor Jonathan Adler said the White House can look at this question all at once, but it is ultimately up to Congress whether the writ should be suspended. Do you agree that only Congress can suspend the right to habeas corpus?
So I think, as you mentioned, that is an issue that is under active consideration by the political branches and could very well come before me if I were confirmed as a judge. So I think in prudence, as a judicial nominee, it would not be appropriate for me to pass on the
Here's the Ginsburg rule once again.
validity of any such arguments.
Okay, thank you.
Senator Lee.
Okay, I'm going to go ahead here at an hour, and we'll just call an hour and 15 minutes into this. It's only got about another 45 minutes or so, but some of this is pretty interesting. I'm going to hold that off until tomorrow. You're right, Paul. To me, is medical malpractice. The doctor should have done what he had taken care of the issue. that child was not going to survive. And it did definitely put the mother's life at risk. So, yeah, it wasn't a problem with the law, it was a problem with the doctor. You heard Amy agree that that exception was in there. The nominee there had mentioned several times that exception was in there. Once again, it's Democrats being Democrats, pretending things aren't what they actually are and trying to use it to bash the other side with it. You're right, Paul. You're absolutely right. So anyway, guys, I've got to go. I've got appointment here in 55 minutes. So y'all have a good day. Enjoy yourselves. We'll pick this up tomorrow. And everyone, try to have a good day. Enjoy yourselves. And as always, be with the ones you love and love the ones that you're with. Later, all.